Yes.
Lordship. Item number 15, Lordship. I am from petitioner. My learned friend is for respondent, Lordship. This matter went to mediation, Lordship, but mediation was unsuccessful. Today we are praying jointly that this matter may come for admission hearing, a date after 2 weeks, Lordship. Okay, he's saying 3 weeks.
3 weeks, Lordship. 3 weeks.
Okay, give a date.
Any date?
Any date as per the court.
Vidya date. Prayer of learned counsel for.
Can it be on 25th, Lordship? There is an interim order operating, Lordship, that may be continued. Deeply obliged.
Please, Lordship. Item number 21 may kindly be adjourned for the day only, Lordship. 21.
Yes.
I might beg to mention item number 18, Your Lordship. The learned amicus who was appointed is out of station, Your Lordship.
Due to absence of learned matter again on.
Obliged.
May please, Your Lordship. I beg to mention item number 38. CD is also available, but today I have some problem, my lord. Can it be taken up day after tomorrow if possible, my lord? 38. CD is also available, my lord. And there is no interim also, my lord. Today I have some personal problem, my lord. Day after tomorrow if possible, my lord.
Personal problem of learned counsel. Given date.
4-2. Highly obliged.
I beg to mention item number 53, Lordship. Of supplementary, Mr. Lordship.
Yes.
Conducting counsel, Mr. N. Hassan is unwell, Lordship. Lordship may kindly take up this matter next week, Lordship.
May please, Lordship. I beg to mention item number 54, Lordship. Kindly adjourn the matter for the day, Lordship.
6.
Obliged. Actually, Lordship, 53 and 54 is same. Obliged.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 13. Your Lordship, we have fixed, we have similar matter fixed on 9th, Your Lordship. Your Lordship may take up the
On 9th.
together on
13.
9th, Your Lordship.
30 otherwise.
We have similar matters, Your Lordship.
30.
No, 13, 1-3.
May it please, Your Lordship, I beg to mention item number 50 and 51 from supplementary list for Lordship. Kindly fix it day after tomorrow, Lordship.
All right. Yes.
Mass obliged, Lordship.
Your Lordship, I'd like to mention item number 16. The matter has been fixed for mediation today, so some time may be granted. Item number 16, Your Lordship.
Yes.
Your Lordship, the interim order passed earlier may be continued.
Wait, please, Your Lordship. I beg to mention supplementary item number 55. I may be allowed for withdrawal, Lordship.
Withdraw.
Yes, Lord.
You are?
I am on behalf of SM Abdullah, MD Imdad.
Your name?
MD Imdad.
Sir, so and so. Praise on behalf of Sir SM Abdullah for withdrawal of the case. Accordingly, the closed upon withdrawal.
Obliged, Lord.
Please, Your Lordship. Lordship, I beg to mention item number 29 and 30. It's called for case there is not received, Lordship.
CD not received, man.
20?
29 and 30.
2930. You did not receive this again on. List, my lord, 24th of February. Then on my lord, 16th of February, 16th of.
My lord, I went to mention one criminal revision with a miscase, my lord. That matter was listed day before, my lord, on 13th, Friday, my lord. But on that day, I was absent, my lord. I was like in another court, and matter was adjourned and fixed, my lord, in the month of March. So I pray, day after tomorrow is the date fixed by the trial court. So I pray, my lord, matter may be taken day after tomorrow, my lord, only for consideration of the IA, my lord, for continuation of the previous bill. I may be allowed to remain on previous bill. That must order, my lord. I'm in trouble, my lord. That is why day after tomorrow, my lord, for IA, my lord.
Why should it be mentioned here?
My lord,
You have to mention before the
matter
senior
was-
bench.
Matter was listed before this.
Have been listed before on that day. On another day, it may be listed before the another bench. This is not a part of matter. You're supposed to mention before the senior bench. Well, run.
If application under section 483 BNSS, your lordship, and offense, a less offense under section 20B and 29 of NDPS, your lordship. Affair at page
Commercial.
page 9,
Commercial.
commercial, yes.
Alright, CD.
Quantity is 29.815 kg.
CD.
Lordship, may I submit a small? Lordship, he had that kidney stone disease. Actually, some cystic lesion was detected. That was diagnosis, and now the infection is going on. Your lordship, his health condition is not so good in the jail. Considering that aspect, your lordship, if short date may be given.
Give a short day. Yes. Otherwise, they can take him to CMC from hospital.
So, during that period, actually, he was suffering from that.
13th.
God bless.
Lordship, record may be called for. It is a charge sheeted case, POXO,
Scan copy of this.
and the notice may go to the respondent number.
So issue notice to respondent number 2.
All right.
Steps within 3 days by registered post with ID.
All right.
May I plead your lordship? Your lordship, 483 application, your lordship. The accused is behind the bar for more than 18 years. The FIR was
18 years?
Arms Act, Your Honor.
Behind the bar for 18 years.
Sorry, 18 days, your lordship. 18 days. 18 days.
CD.
Oblige.
16.
Lordship, the matter may be taken up after some time. My senior is on legs in another court.
How many days?
One.
Hmm?
Matter may be taken after some time, Lordship.
That is your only instruction. You haven't gone through the brief.
Charge sheeted case, my lord.
Charge sheeted.
Charge sheeted.
NDPS.
NDPS.
How many days?
Arrested on 3/11/25.
E11, okay, but search it.
May I please your lordship? 483 application, lordship. I'm behind the bars for the last 41 days. What had happened, lordship? Nothing was recovered from me, but subsequently Arms Act was also what also added, and also NDPS was added. Lordship, co-accused has already filed an bail application that is fixed for day after tomorrow on 4th for case diary.
All right. Just again on 4th along with BA number.
BA number, AB number 115, 115 2026. Deeply obliged.
Your lordship, my lord, this matter is also this commercial quantity. The similar matter is listed today arising out of the same case, Tinsukia
Item
NDPS
number?
case number 46, item number 52, wherein my lord LCR was called for, has already received. And
52, LCR is there.
Yes, 52 is LCR is there. They
Please
are
take up when it is called up. Yes.
co-accused.
$52 look up.
This is a regular bail application, lordships. It is all behind our last 29 days, lordships.
Only.
Lordships. Page 12 is the affair, lordships. My name not in the affair, lordships. Page 12, lordship affair. This is vernacular. 305E, lordships. No punishment, 7 years, lordships.
What to do? CD.
For that, lordships. CD on 13/2. Obliged.
CD में भी कॉल को मतलब निवेपी है
All right, same. order.
सर
27 to 18 to 18.
deeply obliged.
Absolutely, your lordship. FIR, your lordship will find that page 11, lordship, starts from page 12. Your lordship, 1.463 kg of cannabis were recovered, lordship, and he is in custody for 40 days. That is intermediate quantity. Small quantity is 1 kg and commercial is 20 kg. So just a small quantity, lordship, and considering the length of detention, I'm praying for bail, lordship, and it was recovered from airport, lordship, and he stated before the authorities that the baggage was given by the travel agency to deliver to their family members. He was unaware about the same, lordship. And normally, lordship, in airport, this kind of probably a person knowingly would not carry, lordship, because they know that there will be scanners and all these things. And already 40 days in custody, lordship, that rigors of 37 will not come. And his statement is also there, page 30, your lordship will find. All the phone numbers of the persons and names he already disclosed to the authorities, Lordship, whatever was within his knowledge.
Not bad for a student up to class 6, international traveler. CD.
Third date may be fixed, sorry. Next week,
Next week we will produce it.
next week, Lordship, can it be on 10th, Lordship? 10th. All right.
আমাদের না নাকি?
Let the record be called for.
Accepted.
Charge sheet file করা না তো? Yes, it is charge sheeted offensive body.
And copy of TCR along with CD.
Any date subject to your lordship's convenience. I'm not pressing for any early date. I'm obliged.
May I please, your lord? It is April 483, my lord. I am behind the bar since, my lord, 132 days. But in this case, your lordship would find the 48, 47 has been, they have, I have annexed, my lord. He is a cookie, my lord. He only knows the cookie language. But he has been given an English language, my lord. So, my lord, it is a violation of Article 47, 48. That is the requirement in his own language have to be given. So I pray that CD may be called for, my lord, kindly.
Scan copy of TCR, my lord, charge sheeted case.
All right.
My lord, date may be fixed. 21st. 21st. Next Friday.
You conduct a course for your police officers, Kuki, Tiwa, all languages of the Northeast. You conduct a course so that they can send a notice in that language.
In Kachar, they have
And
printed a form in the Bengali and English.
And if you, even if you send it in that language, then they will claim I'm illiterate. I can't read it.
Yes. My lord, what to say? The Apex Code has given the guideline. my lord.
Yes. We know how to implement the Apex course orders.
Very true, very true. My lord, the 21B, my lord. I am behind the bar, my lord.
All right, CD. Short date.
Item 12, item 4, same, my lord. 21B, my lord. I am behind the bar, my lord. 96 days, my lord.
12 when?
Item 12, item 4, same. Same affair. My 92 days base, my lord, charge sheet date. My lord, trial has not started. Your lordship, our High Court has granted several. Your lordship also granted me bail, my lord. I am having a bunch of the cases, my lord.
After CD.
Lord, the charge sheet submitted.
Charge sheet submitted.
Copy of TCR.
So, your lordship grant me bail, my lord. I am giving bunches of your lordship judgment also there, my lord.
That must be after CD.
There, after CD, after there is also after charge sheet, my lord. After charge sheet, our bail has been granted.
Yes, but after perusal.
After signing, then you have to peruse this scan copy. If you want to lodge, I have got no objection. But Honorable High Court, our High Court has granted bail in a series of cases.
The perusal of scan
2020.
copy.
I leave it to you.
Give a date.
May it please your lordship. Lordship, this is an anticipatory bail application. FIR, your lordship will find at page 10, my lord. Page 10 is the FIR. May I read, my lord? Most respectfully, I beg to inform you that I, Zarina Khatun, daughter of Noor Haq, a local resident of village Medobil, PS Fakirganj, Dhubri. I am making this complaint with deep mental injury and hope of justice that on 5/9/2025 at around 3:30 it would be AM, when my husband was absent from home, I was sleeping in my bedroom with my minor son. That time the above named accused person entered my house without having any rights. They knocked on the tin wall, forcefully broke the door of the bedroom, dragged me outside along with a boy named Nazrul Islam of my village. They tied us up with rope and beat us severely with hand and cable wires, causing serious injuries to our bodies. Meanwhile, several of the accused touched my chest and private parts and violated my decency. The inhuman, insulting accused is in a state of excitement, pulled my cloth and made video of this insulting scene. This has been profound damage to social, mental, and personal lives. My lord, the other accused person already approached before this honorable court, my lord, and all the accused person were given anticipatory bail by this coordinate bench lordship after perusing the CD. And the present petitioner, my lord, since he was admitted in hospital and he has undergone an operation, my lord, I have annexed the document. That is why he could not apply the bail petition at relevant point of time. So the health condition, your lordship may kindly peruse at page 21 onwards, my lord, page 21 to 25. He was admitted in Guwahati Medical College, undergone an operation. And the interim absolute pre-arrest bail granted by this honorable court, your lordship may peruse from page 26, my lord. Same FIR, almost all other accused person were granted lordship bail after perusing the case diary in anticipatory bail, my lord. My lord, since health condition is poor, my lord, considering that aspect, till next date, my lord, interim may be given, my lord. All other accused person has already been granted bail, anticipatory bail. The relevant portion your lordship will find at page 28, my lord, page 28. Order passed by coordinate bench of this honorable court. Page 28. Sir, perusal of the CD, my lord, that the present petitioner, my lord. Present petitioner could not file bail at that point of time, lordship, because his health was too bad and he had undergone a surgery, my lord, recently. The actual fact is that, lordship, the informant, she was red-handed, caught it from her husband's bedroom, lordship. She was in some objectionable situation, having some adultery relationship. Lordship, to protect her own image, lordship, she has lost this FIR, my lord. And that part has been considered by this honorable court, my lord, while passing the previous order. And the FIR also lost after 10 days, Lordship.
Page 27 or 1911, para 1, 2, 3, 4. CD. Having regard to the fact is have been granted arrest bail. It is provided. Their arrest, the petitioners. It shall be released on. Amount. Provided that the petitioner shall appear before the IO within a period of 7 days from and cooperate. Matter again on
End of March.
Oblige, your Lordship.
Last occasion, they have appeared. Like copy.
this is item
17, Lordship.
name is shown.
Name is shown, Lordship. Anuddin SK Setri.
What to do?
After 1 week, maybe fix if
Third learned counsel for the petitioner, none appears for the respondent. List the matter again on.
$50. 16. 16 it will come on.
Item 17.
Sorry.
I'm the respondent.
Copy receipt to
I have received the copy ballot.
admission.
Letter may come for hearing ballot. And in the meantime, ballot.
And then, instead of none appears, you say Mr.
I play one thing, Lordship.
appears for the respondent. List the matter again on. For admission.
26. 20
February.
plus. In time order may be continue.
Same order passed to continue till the next date.
Please, your Lordship. It is a charge sheeted case, Lordship. And petitioner was arrested under section in a FAR laws under section 4 of the POCSO Act, Lordship. But in this case, charges have been framed on 1/9/2025. And as of now, Lordship, 2 witnesses have been examined by the prosecution side, Lordship. And petitioner has been in custody for 224 days, Lordship. The Lordship will find the allegation is at page 8, Lordship. Of November.
Service complete, no? Service complete.
If I may read, that's right.
Yes.
Most respectfully beg to state that on last 27/6/2023 at around 5 p.m., my niece so-and-so's minor daughter and my sister went to Bilpar for stitching cloth. Since they did not come back till 7 p.m., I searched them there, here and there, and inquired by my relatives' phone calls, but no information was received. On 1/7/24, at the evening, one Jalal Bepari and Jabbar Ali, who were residents of our nearby Hialbari, informed me by phone.
PCR was called for on the last day, Lordship. Your FIR is at page number 15, Lordship. Intermediate quantity, Lordship. As per bail ejection order as page number 29, my lord, 15 gram recovered from the house of the petitioner, Lordship.
But we go by the seizure list. What is there?
Yes, my lord, I have track mark, my lord, inventory, seizure list, my lord.
In the seizure list, my lord,
37.992
with container, Lordship. Commercial quantity is 250 gram, Lordship.
So, my lord, intermediate quantity.
Page 83 it is Lordship, he behind the bar, Lordship. Moreover, my lord, petitioner and his wife is undergoing IVF treatment in Sanjeevani Hospital, Guwahati, my lord. They are frequent, my lord. Follow-up is necessary, my lord. I have annexed that medical document, my lord. As page number 36 in the bottom, my lord. Once weekly for 12 weeks, they are to visit, Lordship. So, their, my lord, IVF treatment may be hampered because of his tension, my lord. So, I'm saying that he may be released on bail at any condition, my lord. He will abide by the condition, my lord, and face the trial, my lord, and cooperate with the investigation, Lordship.
Is the commercial quantity 50?
50 gram.
250. So here it is at maximum is 35
Yes.
grams, even if we
Yes.
take it at the.
This is also registered under intermediate quantity and thereafter, my lord, charge sheet submitted. my lord.
Learned- I got a little confused because learned session just discussed
Yes.
section 37 in the order dated 8/12/25.
My lord, at that point of time, they are taking the ground of, my lord, section 36B. That was discussed, my lord, and regarding, my lord, sufficient compliance of in the arrest memo, also signature of the witness is there, so that was sufficiently complied. And regarding the medical ground, my lord, he has taken during in the special court also.
That
That
is
was also-
okay, but if it is intermediate quantity, there is no necessity of discussing section
Yes,
37.
man, that's true.
That is why I got a little confused whether what is the quantity.
Yes, sir.
Third learned counsel for the
No, my lord,
application.
learned trial court has not. Yes,
Charge sheet submitted.
charge sheet submitted.
Charge sheet in the case has already been submitted. Yeah. That one body search of the person, comma, 8 grams of suspected heroin along with GABA tablets, YABA. Weighing 6 grams. recovered.
Yeah, but tablet, my lord, this is case of heroin, my lord.
Stated in this case, what is the name of the petitioner?
Petitioner is Ananta Das.
That's it.
Is this
Item number 25, my lord.
Abu Sharma, Sama and Nur Islam? Is this order?
Oh, my lord, this is not the, this is, my lord, BA 410525.
Four one zero five of 25.
The tile code record maybe annexed wrongly, my lord.
State of Assam versus Ananta Das.
Yes, Ananta Das.
After some time, my lord, I will again check, my lord.
Hey, what was the recovery? 38 grams.
37.96 gram, my lord, total.
7.96
weight.
grams of heroin. Okay, rest you cut. Okay. Relates to intermediate quantity. Investigation of the case is over, culminating in a charge sheet. Spent 83 days behind bars. Cut to the same airport. Bail is allowed. Thousand with like amount. Code below. It is connection with the aforesaid case. Regularly participate in the trial if influence or intimidate the witnesses.
Good day, Lordship.
Six, my lord, scan copy of TCR receipt. Report awaited, my lord. Service report awaited, my lord, not yet.
Steps were taken, I think.
22.
To police station, I think.
Ambari police station. I will get the instruction.
appears that registry had issued notice to the OC, Tasil Ambari PS, served notice upon the respondent number 2, but no report in this regard is received. Garnet additional PP, take instructions in this regard. Raise the matter again on day after tomorrow.
Yes, yeah.
TCRS call for has been received.
Thank you, boss. The regular bail, my lord, arrested on 22/11/25.
73 days.
Today is 73 days, my lord. Statutory period is 90 days. Only question, my lord, your lordship, kind is the last orders. 2 orders, your lordship, kind of say his serious condition, he was supposed to undergo operation. And for that, my lord, 22/01 and 22/1/26. Both orders kindly go through, my lord. then. এই দুটো রাস্তা কোনটো এটা
Did you approach the jail authorities, your
Jail
family
authority, madam,
members?
that day, we approached jail authority, then thereafter she was sent to that, for that, the operation. Then they said that it is a serious operation, some spinal something. One person will be required that is not allowed in the jail. Oh, my only question, my lord, this stage 73 is already done, my lord, and she is not minor also, my lord. She
What
is
is not
major.
allowed? What is not allowed?
So,
Family member court order is there.
no, the your lord's kindly see the order is, order, order is, first order was. Pay 20 your lord's kindness. As per advice, I am reading second paragraph, last portion. As per advice given by the doctors of the Guwahati Medical College and Hospital, surgical intervention is required. However, on 10/1/26, the accused had to be recalled from undergoing surgery in the absence of any family members to assist him. It is therefore prayed that the petitioner may be allowed to go on bail by giving so and so. The Rani Additional Prosecutor has submitted that petitioner being afforded all medical facilities during the period of so and so. In view of the submission made at work, the House have considered opinion on the ends of justice medical detention. At this stage, if any family members is allowed to so and so.
We approach.
Huh?
We approach.
So we approach the jail authority and the jail
He also admitted jail.
jail authority said that he is to be admitted in GMCH. And thereafter, you will also kindly say what statement we have made also here. Yes. I'm only on that part, my paragraph 7, your loss kindly see of my petition. She is major, 10 majority, the court's finding also is there. Page 33, 34. I wonder whether my ends of justice, my already 73 days further custody is not required. In the interest of his health, only my personal care should be required. paragraph 7 and 8, my lord, my
where do you find the age?
your lordship, paragraph 33, 34 kind of one.
Hmm?
33, 34.
Age.
Yes.
That is, my lord, at the time of recording of the statement.
Yes, page 34. Registered swallow. As regards the Jumma of the victim, as she is major, hence I was required to transfer.
That is on 2011,
Yes.
25.
Yeah.
And
Date of occurrence also
occurrence is
14/11/25.
No, my lord.
No, Lordship.
Huh?
The FIR clearly says
FIR is dated
since
18/11.
blackmailing since 2 years. So
No,
it
no,
will
that-
be years prior to the lodging of the date of incident.
No, FIR is dated 18/11/25. Date of occurrence 14/11. As per FIR.
The Lordship kindly sees page number 12 of the
FIR. And there in the FIR, they have written my lesson. Their boys couple
14/11/25 was the last date, but it was initiated long before, as per the
The statement
FIR.
of that here, my lord. No matter further custody is required or not, my lord, be on the statement of
Lordship,
that.
I have received the case diary, my lord, along with medical report also. And date of, my lord, birth certificate is also there, my lord. As per the, my lord, birth certificate, her date of birth is 1/11/2007. And in her statement also, my lord, she stated that since 2024, my lord, offense is, my lord, going on. And at that point of time, she was minor, and now at the time of recording of the statement recorded on 2011/25. At that point of time, she was about, my lord, 18 years.
Immediately after filing of the FIR, my lord. That order was passed.
The time of recording of this.
And she filed idea on FIR against her own brother-in-law, my lord. That is also we have an page 22. Her statement, how far married to believe, my lord, page 22. On 12/10/25. Registered, sir.
It would have become major only by 1/11/2025.
Yes.
On 7. 14, date of occurrence.
No, that is the date of the last occurrence.
Yes, my lord, but
It was before, and so it is, section is squarely attracted. Section 6, repeated
And she filed another case RDA also, my lord. The first work, that also, page 22. Oh, another person she filed. Page 22.
What happened there?
Yes, that was registered in that case, my lord, that order which your lordship has, page
Huh?
22. Page 22. It was filed on 12/10/25. That also registered under POCSO. And in that case, my connection, that page 34, 33, 34 comes, my lord, in connection with that case. Father of the victim is saying, my lord, that I have no objection if it is given to the page 31, page 31. Which one you also will believe, my lord?
Prior to 14. This is,
My lord, UAPA section 18, my lord, explosive substance act is also there, my lord. Two judgments of the coordinate bench of our High Court, my lord. Your lordship. But because those are scheduled offences.
Lordship,
my
in
lord,
this
under-
case, co-accused has also been granted bills under the same section, Lordship. I have annexed here in the annex E, Lordship. Page number 42.
appeal is
When this
made-
FIR was lodged, Lordship, FIR was lodged on 14/9/24, and the accused was in another case, in another case, he was behind bar since 2019, 25/5/2019. And here in this case, the FIR was lodged on 14/9/2024, Lordship.
Your lordship may kindly peruse, my lord, bail petition, my lord, 1727 from paragraph 7, my lord. Mamanur Rashid, my lord. Otherwise, your lordship may kindly take up this matter at 2, my lord. I will also.
In notice under section 47 of BNSS, Lordship, the brother of the accused, his signature is not present, their lordship. And in the arrest memo also, the person who's
Now we are on the, he is raising a question of maintainability, that is. So in this coordinate bench judgment, it has been held that it's not maintainable.
Yes, my lord. And regarding that, because limitation point, my lord, regard to consideration, for consideration of that limitation point, my lord, matter referred to the division bench in, my lord.
It cannot, regular bail does not lie, it's an appeal.
Appeal, yes, my lord. In the, my lord, DA number 1727 regarding limitation point, that matter referred to the Honorable Chief Justice, my lord. The second case, my lord, on that point also, my lord, was considered, and ultimately on merit also the bail petition was. Will hand over the, your lordship, kindly.
It was rejected by special judge.
Yes.
yes.
Then-
No, lordship. Here in Tongla PS case, he have not filed any bail petition. The first bail petition. Yeah.
Then it would be even less maintainable. You have to go to the special court first. As far as this judgment is concerned. Those two are cases where bail was rejected by special court. So appeal lies. In this case, they have come directly. Under 439, presumably.
Here. Oh, I
It will take up day after tomorrow. IDPP submits that the instant bail application is not maintainable in view of section 21 of the NIA Act. Placed before this court. Decisions of coordinate benches of this court in this regard. The matter needs to be heard at length. Hence list the matter again on day after tomorrow, okay?
Your lordship. For 83 bail application, my lord, the petitioner in custody for 66 days, my lord. FIR is type copy of the FIR is at page number 11, lordship.
It is here.
My lord. PM report received, but PM report, my lord, regarding cause of death is kept pending till receipt of the chemical examination report of this. My lord.
Moreover, my lord,
Where's the FIR?
page number 11, lordship, translated and type copy, my lord. And Assamese version is at page number 12, lordship. Is in custody for 66 days, lordship. Moreover, my lord, section 36 of BNS was not complied with. I have annexed the address memo, my lord, page number, my lord, 15 and 16, my lord. It does not contain the signature of any witness, lordship. Investigation might have been completed, lordship, so my lord, I pay for releasing him on bail, my lord, at any condition listed. He is also aged about 19 years, my lord. Behind the bar since, my lord, 18 to 25 also. Coordinate bench of this honorable court, my lord, similar cases granted bail for non-compliance of, my lord, section 36, my lord. And also non-compliance of the judgment of the DK Basu, my lord. I'm wording this order. Paragraph 7 and 8, lordship. Order of, my lord, Abu Sama and another, my lord. Where, my lord, DK Basu was referred to, my lord. DK Basu, paragraph number 35, lordship.
Yes, PP arrest memo doesn't appear to bear the signature.
In the case diary, my lord, I have not found the copy of the arrest memo, my lord. Yes, my lord, signature is not there.
Number date him.
Yes, CD number.
Yes.
Under section 21 B and 27 A of NDPS lordship, I have been in jail since more than 2 months, lordship.
3, my lord, charge sheet submitted in this case.
So what to do?
Scan copy of this here may be called, otherwise we'll let him appear before the trial court, my lord, first. Case of rejection, my lord.
What do you want?
Let us try my luck here, lordship. Let the
Scan copy of TCR then. Should have been submitted white CS number.
CS number 309/25, dated 31/12/25.
Ma'am?
Pradip Nair.
Biplab Lal.
Can you take this matter after some time?
Lord, scan copy, my lord, call for my lord. And in the meantime, my lord, out of 12 witnesses, my lord, 7 witnesses already examined, my lord. Out of 7 witnesses, my lord, I include the evidence of all 7 witnesses. And the remaining 5 witnesses out of 5, my lord, 4 all official witness, my lord, OC, SDPO, my lord, office of the Sir of the government. My lord, I have enclosed, my lord, evidences of my lord, 7 witnesses. That's from my lord page. That's from my lord page 34. None of the witnesses, my lord, implicating the my lord, these 2 petitioners, my lord. They are saying, my lord, all the independents saying, my lord, we put our signature in the seizure list in the police station. We do not know where from it was the one pistol and other mobile phone recovered.
Before submitting my senior, my lord, I have also gone through the record, not gone through the record, my lord. But I will take it after some time, my lord. Or any other day, my lord.
All right.
And at my lord, 2, my lord. 2, my lord.
Let us see.
My lord, my lord.
May it please your lordship, kindly pass over it for a week.
Or
This CD also not received, my lord. No listener, no? 35.
all right, updated CD
My
not
lord.
received. List again on so and so interim order passed earlier to continue till the next date of list.
That is 19th, my lord. 19th.
Made your lordship. Lordship, the FIR, it's page 11, lordship, is registered under section 4 of the POCSO Act and read with section 351(2) of the BNSS. However, after the charge sheet has been filed, the section have been changed to 354 and section 12 of the POCSO Act. And in addition to this,
My lordship, the investigation has substantially progressed, my lordship. Substantial time has elapsed, my lordship. So lordship may currently at any condition, terms and condition, give interim protection if something incriminating in the charge sheet of the PCR record, the lordship cancel the bail, my lord. But at this stage, my lordship, may I just pray for the interim protection? I may be allowed to produce before there.
Where is the bail order?
Bail order, my page number 36, my lord. I have attached, my lordship. Main accused is the husband of the present petitioner, my lord. Same household, my lord.
I was granted default bail.
Lordship, at any terms and condition, if something incriminating, because nothing have been produced, but 3-4 months elapsed, my lordship. Only this case, nothing have been given, my lord.
Search is submitted, lordship. Lordship may kindly call for the TCR because lordship 103 is involved, lordship. Going to the CD.
PM report clearly says due to coma as a result of injuries sustained over the head. Can you say it's not inclusive or
She
whatever?
is ready to face the trial, my lordship.
Everybody has to face the trial. Do you have a choice? Face the trial.
My lord.
Call for the TCR. Submitted. Charge sheet has already been. TCR as called for has not been received. Additional affidavit has been submitted today. On behalf of the petitioner. Reminder for transmission of the scanned copy of the TCR. Along with CD. List again on.
19, lordship. 19-2.
Safely applies, my lord.
Please, lordship. With CID case, 50 number. I have appeared.
Rejected earlier.
Yes. Not rejected. My recording, my statements has been recorded. Lord.
CD we have received, lordship. 5 4 lordship. We could not put a big voluminous case, lordship. 5-6 files, lordship. So we could not.
Only day after tomorrow. Prayer of learned edition. Has submitted that a voluminous CD has been received.
Technically fixed on 5th, lordship. Day after
The
tomorrow,
matter again on 5th.
Oblige. CD receive, my lord.
If we try to get with the petitioner, but your convenience may pass any order.
I can't read your lips. Please speak up so that I can hear what you are saying.
Lordship, we try to communicate with our petitioner, but we unable to communicate with the petitioner.
What is the need for communicating with your petitioner now?
We have no instruction, Lordship.
What instruction? Material instruction. That is your fault.
I don't know.
Is there?
My lord, CD receipt, my lord. Here, my lord, from the statement of the my lord, 183 statement of the my lord victim. There is implication against him, my lord, and medical report also supported, my lord. She is 5 months pregnant at that time, my lord. And from the IO report also it reveals that, my lord, he has taken some documents, my lord, voter ID, PAN card, etc. But he has not returned. But in his statement, he also denied. And I also said that he is not cooperating with the investigation, my lord. Not denied all the things, my lord. All that PAN card, etc. taken by him, my lord. Such as Aadhaar card, ATM card, voter ID, PAN card of the Kiran Busumate along with birth certificate of the sons Kiran Busumate are alleged to be wrongly detained by the accused. However, the accused has denied the same, manner.
Learned counsel for the petitioner submits that she has no instructions from the petitioner. On the other hand, learned PP with reference to the CD submits that there are sufficient material against the this hence matter again on so and so. There are having regard to the submit learned and PP. The interim order passed earlier dated 15/12/25 stands vacated. List again on so and so CDB retained. Supervisor, this is-
Friday, man. Sixth.
Item 34.
Please, Lord.
No, legend.
Item 34. 34. 34, 34. My lord, this is regular bail application, my lord. Petitioner number 1 is behind the bar since 88 days, my lord. 2 is behind the bar for 51 days, my lord. FIR is at page number 11, my lord. Both parties filed FIR against each other, my lord.
My lord, after some time, my lord, Botagora has gone through the record, my lord. 34. Yeah, wait,
34, right?
Where is the FIR?
My lord, page number 11, my lord. My lord, so far as the FIR, my lord, there is no any active role of the petition number 1, my lord. Otherwise, there are materials, some materials against the petition number 1, petition number 2, my lord, who is the accused number 1. Petition number 2 is a packaging advocate, my lord. Some of the incident happened, my lord. 88 days, petition number 1 completed 88 days, my lord. 88 days. 88. Number 2 अपना 51. days. Page number 21 is the cross FIR, my lord.
Who are the petitioners? Kobindra.
My lord.
And
Mukut Bharali and Kobindra Bharali, my lord. Number 3 and accused number 1, my lord.
Yes, Bhattakur.
Yes, my lord, case they received, my lord. PM report also received, but PM report regarding my lord cause of death, my lord, is not, cause of death is pending, kept pending till the receipt of the.
Any cut injury
Yes,
as
my
mentioned
lord,
in the FIR?
There one, my lord, cause of death is, my lord, as a result of, my lord, injury, my lord. That one GMCS, my lord, regarding one report of the GMCS is also there, my lord. Regarding injury in chest, and here, my lord, two petitioners regarding 1 and 2. 2 is the main accused, my lord. He, my lord, assaulted the victim with dao, and as a result of which, my lord, he succumbed to the injury. And my lord, regarding that aspect, eyewitnesses statement is also there. And my lord, in respect of Mukut Bharali also, my lord, there are materials. Mukut Bharali attacked, my lord, Ujjwal Das, my lord, with a sharp weapon, for which, my lord, he, my lord, but that injury report is not available, my lord.
We are Mukut Bharali and Kobindra
Kobindra.
Bharali.
Bharali petitioner number 2 is the main accused, my lord. He is the person, my lord.
No, he is petitioner number 2, accused number 1.
My lord. For one petitioner number 2, my lord.
He is the main.
Yes, my lord. Because of his assault, my lord, with sharp weapon, that is dao, my lord, the ultimately, my lord, victim injured and ultimately died at expired at GMCS, my lord. And regarding that aspect, my lord, all eyewitnesses stated about the, my lord, the present petitioner number 2, Kobindra Bharali, my lord. He assaulted the.
And
my
Mukut
lord,
Bharali?
Kobindra Bharali, my lord.
And Mukut Bharali?
Against my lord, Mukut Bharali is also, my lord, statement. He also assaulted the son of the informant, my lord, with sharp weapon, my lord.
Both parties sustained injury, my lord. We have also lost against.
And this is the, my lord, PM report regarding injury, my lord.
Perhaps, my lord, further custodial detention may not.
Petitioner number 1, he is, as per my submission of the petitioner, he has completed 88 days. And regarding Kobindra Bharali, petitioner number 2, who is the main accused, he has completed only 51 days.
Can we like consider the length of detention? Tell up to them. Somehow happened, my lord.
It appears everybody acted in concert together.
There are specific material against these two petitioners. Specifically, my lord, eyewitnesses stated regarding the Involvement of the.
Learned counsel for the petitioner and learned it. So and so, as per the allegations reflected in the prior. Is 14 of Pabo, first information content. Learned for the petitioner submits that the petitioner number 1 has spent how many days?
88 days, my lord.
88 days behind custody. Petitioner number 2 has spent 1 days
51 days.
custody, and considering the length of detention, bail may be considered. Para on the other hand, learned additional people on perusal of the CD submits that incriminating material against the present petitioners, including the statements of eyewitnesses regard to the above as well. Gravity of therefore bail stands rejected at this stage. Like the CD.
Highly available.
May I please, Your Lordship? Your Lordship, in this, here the petitioner is the owner of the vehicle, Your Lordship. His name is not in the FIR also. The IO has put his name in the charge sheet as absconder accused, Your Lordship. There is nothing have been found from his position, Your Lordship.
Vehicle was used, Lordship, and from that vehicle, Lordship, 50,000 of Yaba tablet recovered. Lordship, wait at 30 seconds.
Your Lordship, in a similar case, Your Lordship, this honorable court have given bail to an accused, Your Lordship.
What is the material against him? Is the owner?
It was used, and that has been intercepted by the police. And that too, Lordship, that one thing is important, Lordship, that there is a secret chamber made near the tank, oil tank, Lordship. So, Lordship, without his consent or without his information, that cannot be the Lordship.
Was used by another person, Your Lordship, Abdul Sadiq, Your Lordship. And nothing has been found from his position, Your
But
Lordship.
only
Even his house was not searched, Your Lordship. It's just that he's the owner, Your Lordship, nothing else, Your Lordship. None of the accused have in their statements given anything against him, Your Lordship.
CD is there.
PCI is there, Lordship.
It is there. You will see.
Knowledge that secret chamber cannot be.
May I please, Your Lordship? Lordship, my senior is not well. Please take the matter after break.
He is not well. Let him go home and take up after. Monday.
CD received my written.
Obliged.
Monday. Monday.
First call for my lord.
CD we have received also.
The petitioner is interim, my lord.
Allegation is lordship slaughtering of cow and selling of meat person.
My lord, they are appearing before the court, before the Thana, my lord, and recorded their statement, my lord. Whole material has been recovered from one ammunition, my lord. Not in the present. House letter in the house of ammunition, my lord, but he is not in petitioner, my lord. The three petitioner were granted interim bail and they were appeared before the IO and their statement was recovered. That custodial interim. Pension is not.
The name of the petitioner?
Three petitioner, my lords.
Idris Ali. He's
Idris Ali.
arrested.
They were on interim lordship.
They appeared.
All the three petitioner are interim, my lord. Idris Ali, Abdul Hasid, and Ali Hussain, my lord. They cooperated and appeared before the IO and their statement was recorded, my lord.
That is not the cooperation lordship.
When in your statements you have implicated yourself.
My lord, Abdul Hussain and Ali Hussain are not present, my lord.
Not present, but they appeared and said we did it.
My lord.
They appeared before the IO and admitted.
My lord, no, my lord. Abdul Hasid and Ali Hussain is not no way connected, my lord.
Their statements at the lordship.
On that day, they are not present, my lord.
They say they were involved in selling.
Perhaps Idris Ali is involved, my lord, but Abdul Hasid and Ali Hussain is not involved, my lord, as per my instruction, my lord. They are not present at the time of
Photographs are also there lordship. When the police came, they fled away. Some took photographs also. That is also there lordship.
Ali Hussain doesn't appear to be any material. Ali Hussain.
And Abdul Hasid, my lord.
He admitted he was with the weighing and everything.
My lord, they had appeared, my lord, so further custodial detention is not necessary, my lord. Is the time, my lord.
Additional PP.
There are three petitioner, my lord.
Fire. Paragraph 2.
FIR, my lord, one Amir Hussain, my lord, his house.
Pursuant to interim protection, petitioners had appeared before the IO. Their statements the involvement of the petition number 1 and 2 are apparent from their own statements besides other implicating material. However, the involvement of petitioner 3 appear to be the material on record. That I having therefore pre-arrest bail in respect of petitioner number 3. The bail in respect of it in view of that of interim pre-arrest as far as Ali Hussain is concerned, hereby made absolute. Like the CD.
Apologize.
Kedari was called for. FIR is in page 8, my lord, 9, my lord. Stated copy. Allegation is that, my lord, theft of batteries of e-rickshaws. The actual fact is that, my lord, I purchased some second-hand batteries from one Robin Shah for using my e-rickshaws, my lord. Later on, when police came to my home, my lord, then I came to know that those batteries were stolen, my lord. But those were not stolen by me, my lord. I have bona fide purchased a second-hand battery, my lord. Batteries were recovered from my possession, my lord, from my house, my lord.
Yes, PP.
You have received lordship, and those batteries were recovered from his house, and even his own his wife has a wife statements is there, lordship, wherein she has stated, lordship, that where from she has stolen it I do not know, but he has stolen it and kept it in our home. 7 numbers of battery recovered from his. They are the e-rickshaws persons, lordship. They are the sole owner of with that, lordship, and that battery has been stolen from them.
I purchased, my lord, second-hand batteries, my lord.
There is
All
no any-
batteries have been already recovered also.
There is no any proof that that has been purchased or not. There is no any.
Case of pre-arrest bail.
All batteries have been already recovered. Probably, my lord, custodial interrogation may not be required, my lord. This case.
Time behind bars is required actually. Learned counsel for the petition and learned edition. An application under page 13. Effects of the case. The result of the CD submits. There is sufficient material in the petition. Of the e-rickshaw batteries. Regard to the above. Present case is not considered to State case for grant of privilege of pre-arrest bail. Therefore, pre-arrest bail stands rejected with CD.
Obliged.
Yes, sir. Question আছে যদি?
Lordship, service report awaited, Lordship. Boxer method.
Already received, my lord, as per office note, my lord. As per office note, my lord.
That is no, that is that you আপনি steps level reported.
Other side to receive, করেছি।
And copy of TCR is received, but service report not yet received. Await service. Is taken on.
Really obliged, your lordship.
My lord, better maybe fix it too, my lord, kindly.
Where is it listed? CD is here. All right.
Status report was called for. We have not received.
CD was called for.
Yes, called for, my lord.
CD received.
Not
Not received. Not received. List again on.
That may be.
ABD. 17, Lordship.
Yes.
Item T8, Lordship. As per the settlement process, payments are being made by the petitioners also. Altogether, 8 lakhs 20,000 has been made. Out of 13 lakhs 20,000 also.
So you are getting
My lord, getting, my lord, now the balance is, my lord, rupees
5
5
lakhs.
lakhs. The balance, my lord. For the last order, my lord, lordship.
So we keep this pending for some time.
My lord, lordship, fix a date, my lord.
Submitted by learned counsel for the respondent that an amount of is
8 lakhs 20,000 also.
20,000 paid and
Balance amount of rupees 5 lakhs.
balance
yet
amount
to be
of
paid.
rupees
5 lakhs.
Is yet to be paid, my lord.
5 lakhs is yet to be paid. Is the matter again on.
Till them are, lord, they may.
No, we'll
Pay the
keep
entire
on
amount.
paying also.
It is submitted that in the meantime, petitioner will continue with the payments of the remainder amount.
Also.
All right.
All right.
Deep them.
Thirteen. 31. 31, yeah.
My lord, yes.
My lord, anticipated bail requisition 14 is the FIR, my lord. This brief facts, my lord. The only submission is that, my lord, this hired card, some arms battalions, they are in duty, the 4 and 5, they are teenagers, they are gathering there for some drinking, and they are instructed to leave this place that was defied, and heat altercation and some there is a hindrance to discharge of duty. Then another some allegation is that some grievous injuries sustained and damage of this vehicle, and the wristwatch was taken away, my lord. But here, as a common persons, I think that there are 7 or 8 constable or commando, I think maybe arms battalion. Really they can overpower them. However, maybe, my lord, here, my lord, when forwarding, one was arrested. When forwarding reports, page 18, it shows that all are gagged up. In FIR or in forwarding report, no specific name was mentioned. All 4 or 5 youths, they are gagged up doing these mischiefs, my lord. But when, my lord, they are in one accused was granted bail, page 20, Annexure B. Here, page 21, it appears that IO has submitted an objection petition, but he has raised objection to granting the previous bail to accused Sagar Mallu and not against the Devojit Das. So when FIR's forwarding report is given, no name is mentioned. It is a common mischiefs, my lord. They are not that they're dacoity, they are go there for a dacoity, or they have some intention there. It is just their drunken stage, heated altercation is done. My lord, if another allegation is they are all available except grievous hurt or, my lord, this robbery. Robbery would not come, I think, in the heat exchange or this something happens or not, I don't know. But no, they are gagged up. That is their forwarding report says. So my humble submission is that he is and the accused is a teenager, 24 or 5 years, and out of his house for such a long time. Maybe in drunken stage, they could not understand this consequence at 11:30. So already he has suffered a lot. He may allow to surrender. If actually he is involved, then he will be honest, my lord. This is my humble submission, my lord. Otherwise, they are not with weapons, or they are waiting for not a terrorist or nothing like that. Only just gathering in cold days, my lord, winter days, they are with drinking. And they have done mischiefs. Police has instructed them to leave the place, they defy it. Engage heated exchange with this police. And police are armed personnel. So there is grievous hurt, there should be some recovery of weapons or like that. Otherwise, this is exaggeration. The vehicles is not a police vehicle, this is hired vehicles. Come by this police at 11:30. Considering all these things, and he will surrender at any terms and conditions for which he will appear. If it is.
These persons are they are in drunken condition. It is true, but what they are doing, they are making some nuisance, creating some nuisance in the when police went there and police asked them to stop that, then they alter, and there are eyewitnesses, lordship. The eyewitnesses also implicated them. They are the independent eyewitnesses, lordship. Lordship, they are trying to snatch the.
But in FIR, my lord, no mention
Even
about
their
that.
co statements are also there, lordship. They have also implicated
So
the
that-
beating. And this is the he is the main person, lordship.
Trial will be there, my lord. Then they will face the consequence, my lord. At this stage, my lord, one cannot say policeman, I'm not satisfied with him. That is why he said, I don't know that this matter.
Persons are not nowadays safe. If they are being assaulted,
How can deter
Maybe
a
Lordship, because if only because of they are with armed, they cannot use the arm at any moment, anytime.
deterrence is this is common prudence men cannot believe that they can deter a armed commandos, my lords. So his mother is suffering, is out of all suffering is gone through last 2 months. He may surrender his family also.
Reports are also there, Lordship. It is not the simple injury. There are several injuries are there. Not is one more injury, no, Lordship. There are several injuries are there, Lordship.
So names should be all at least
Simple. But
for
hitting the officer, police.
they are
person,
gang up, my lord.
that is-
Forwarding reports kindly say all are gangs up, then try to snatch like this. My lord, there is no specific that he has particularly with weapons or in the bed or something that hit, something that is nothing, my lord. The scuffle, my lord, at night 11:30. My lord, it is matter of investigation, my lord. Trial maybe will definitely suffer consequence. At this stage, my lord, maybe consider because his family is suffering, my lord, only mother is there and poor persons. Premeditated things is not there, provocated something, some team come, ask them to leave, they are drunken stage, they also engage alternate.
It's not the provocation, Lordship.
It's because intoxicated, that is why.
Police cannot
Otherwise,
provoke them.
if they are in sense
Asking
that
them to leave
definitely
this place, that is not a provocation. That
with
not
not
submission may not be.
with premeditated intention is absent, my lord. If they are drunken states, that affect them to do that. Or everybody was present, not single persons is there. That is the condition, my lord. Otherwise, in normal condition, I don't think that this happened. Any condition, my lord, surrender immediately.
Let's.
My lord, I was submitting, my lord, 12 charge seated witnesses are there, my lord. Out of 12, my lord, the 7 witnesses already examined, my lord. And one is, my lord, the Pradeep Chaudhary, independent witness. 2 is Jagadish Bonia, is also independent witness. 3 is informant. 4 is independent witness, BTP secretary, my lord. And 5 is independent witness, Amar Doimari. 6 is ASI, Rafiqul Islam. 7 is, my lord, the police personnel, Kusum Kalita. My lord, 5 remain to examine, my lord. 5 out of 5, my lord, 4 are police officers, my lord. And 4 are officers, my lord. Almost all, my lord, the independent witnesses, my lord, examined, my lord. And, my lord, this petitioner, my lord, behind the bar, my lord, for more than 9 months, my lord, 279 days. Since, my lord, 30 of April 2025. And, my lord, article recovered, my lord, 1 pistol, some ammunition, and 7 number of mobile telephone. Mobile telephone, if not my lord, objectionable article recovered from the mobile, my lord, then there is no, my lord, justification or, my lord, the reason to seize by mobile phone, my lord. Only 1 pistol, my lord. And that, my lord, in the pistol seizure list, my lord, informant said that I said in presence of the witnesses. But, my lord, witnesses, independent witnesses says that where from it was recovered, when recovered, nothing told to them. Only, my lord, their signature obtained in the police station. Kindly see, my lord, 1 cross-examination of informant, my lord, that is page, my lord, kindly see. Page, my lord, 38. Page 38. The informant police officer, my lord. Relevant person, my lord, page 40. Page 40, my lord, he is stating like this. I have not informed the local Gaobuda, VDP secretary and other person of Thausubari village to accompany to the place of occurrence. I have not mentioned the reason why local persons Thausubari village were not informed to accompany to the place of seizure. I have not mentioned the weight of length of the seized article in my seizure list. I have not mentioned the country name, and also I have not mentioned the serial number of ammunition in my seizure list. I have not mentioned the region under what circumstances I was compelled to conduct the search in the night hour. I have also not mentioned in my seizure list about the sufficient light at the time of search. These are, my lord, the statement, the cross-examination of the informant, my lord, at page 40. And, my lord, other, my lord, witnesses, nothing incriminating material, my lord, against the petitioners, my lord. The lordship can see, my lord, this evidence of PW1, that is Pradeep Chaudhary. In cross-examination, he said, I do not know from where and from whom the arms and ammunition were recovered. Police did not show me the arms and ammunition at the time of taking my signature in the seizure list. I put my signature in the seizure list at the police station. This is the PW1. PW2, similarly, my lord, police did not show me any arms and ammunition. They just took my signature in the seizure list. Police also did not disclose about the seizure list. I also do not know from whom and where the said arms and ammunition were seized. Then, my lord, PW4, kindly see, my lord. This is, my lord, page 45, my lord. Page 45, he is Arjun Limbu, he is the BTP secretary, my lord. One day I went to Tangla police station to attend a meeting. I am a VTP secretary. Then the police told me to put my signature on a seizure list. I do not know why my signature was taken. This is the chief, my lord. Cross. Police took my signature in a blank paper at the Tangla police station. Police did not show me any seized article at the police station. This is 4, my lord. 5 of similar line, my lord. 5 is Amar Doimari. I know the accused Jitu Loha Basumatari. Loha Basumatari work together to earth filling in our locality. The profit of rupees 5,000 rupees was in the account of the accused. Loha Basumatari I asked my share from the accused Loha Basumatari and he gave 1,500 to me. I do not know anything regarding the case. This is my lord 5. 6 is my lord Rafiqul Islam. He is my lord ASI, a police my lord. IO Mirinal Tide has seized 5 mobile connection with the PS case number so and so. IO Mirinal Tide deposited the said mobile and other articles to the Malkhana. In cross, I cannot say from whom the seized mobile were recovered. I have not seen the seized mobile and other article in the court today. I have not some.
My lord, on the lead by the
No seizure was made, not even shown to the independent witnesses, my lord. So it is a fit case, my lord. It is a fit case, my lord. At least, my lord, after 9 months, my lord, there should be granted bail, my lord. And my lord, one more thing, my lord. One accused already granted bail, my lord. Kindly see, my lord, this order. Order, my lord, at page, my lord, 30, relevant person is 31. Loha Basumatari granted bail of rupees 30,000 with one security like amount. Long back, my lord, granted bail on page, my lord, 30-31. On 24/9/2025, long back, my lord, he was granted bail. Last person, my lord, is 31, page 30. But our case of the petitioner registered, my lord, that is why here before lordship, my lord, the rejection is order is page 28 and 29. Search was made, my lord, during the night at 3:30 a.m. Except, my lord, one pistol, no objectionable article.
that is sufficient for the conviction of the accused person, my lord. Here, আপনার হয়েছে? Lordship, here the allegation against the present petitioners are very serious in nature, my lord. They have purchased some arms, my lord, from Manipur, my lord, to form an unorganized, my lord, organized, my lord, to collect money, huge amount of money, my lord. And from the statement of the witnesses, it reveals, my lord, and on the lead by the present petitioner, my lord, the arms were recovered, which was kept in, my lord, different places, my lord. My lord, from the statement of PW3, my lord. PW3, my lord. My lord, seizure list is there, my lord. Seizure list is there, my lord.
Usually
I have
there,
checked,
but
my
my
lord,
lord,
seizure.
out of 6, my lord, accused person from whom
Seizure list is there, my lord.
in the charge sheet, my lord, it
I
is
have
mentioned.
checked, my lord.
In the charge sheet, it is mentioned, of course, my lord.
And my lord, against the present petitioner, my lord, Dawharo Boro, my lord. 12 cases pending, my lord, against him, my lord. He is the ex-NDFP person, my lord. 12 cases is pending against him, my lord.
My lord, my lord, if I am not fully correct, my lord. 6 cases already disposed, my lord.
No, I am,
Acquittal,
I am
in
saying about
acquittal.
the record, my lord, from the record, my lord.
No, I have instruction that yes, a case were there, but my lord, already, my lord, in 6 cases,
12
my
cases
lord,
are
they
there
have
against
been
him, my lord.
acquitted. My lord, petitioner number 1, but in case of petitioner number 2, my lord, there is no such.
Flag mark,
cases
my lord,
pending.
Caesar list. In the scan copy, my lord. From the statement of the co-accused and other persons, especially it is revealed how they have planned to organize, my lord. There, my lord, scan copy of the record, my lord. Only 3 witnesses are there, my lord. Other 4 are
No, I have
to
sub-
examine, my lord.
I have
It is not
submitted before the court.
available in the record, my lord.
So the statement of Kuiku is now not relevant because my lord trial is going on. Already 7 witnesses, my lord, already examined, my lord. Whatever they have to deposit, my lord, they have to deposit in the before the trial court, my lord.
183 statement of the one of the, my lord, witness, my check mark there, my lord. 183 statement. No murder, my lord. No, my lord, he is, my lord, he also offered to join in their organization, my lord, but he refused, my lord. He also tried to engage several persons, my lord, youth, my lord.
Prosecution may, my lord, examine the court in the calling in the court. Support of the case, my lord. But my lord, a charge sheeted witnesses, my lord, out of 12, my lord, 7 already examined, and my lord, remaining, my lord, 4, my lord, all are police officers, my lord. The charge sheeted, my lord. Charge sheet, my lord. My lord, yes, page, my lord, page, my lord, page, my lord. Page 19, my lord. Page 19. Number 1, Sushil Dhanwar, who is the informant, 2, Pradeep Chaudhary, 3, 19 and up to 20. My lord, they, what this, my lord stated before honorable trial court. My lord, yes. Independent witness, my lord, this is informing saying, my lord, so. But what the independent witness saying before honorable court, my lord, that is, my lord, relevant. Independent witnesses, my lord, I have already stated, my lord. The PW1 is the independent witness, Pradeep Chaudhary, PW2, Jagannath Bania is a cultivator, independent witness, PW3 is the informant, 4 is, my lord, Arjun Limbo, a BDP secretary, is a independent witness, and 5 is, my lord, Omar Doimari is also independent witness, 6 is ASI Rafiqul Islam, 7 is Kusum Kalita, is a government employee. 1, 2, 4, my lord. 4 VDP secretary. And 5. 1, 2, 4, 5.
My lord, the record not available.
Five, my lord, Amar Doimari, my lord, is a daily worker. And
Only 1 to 3 is there. my lord.
and four is Arjun Limbu, my lord, is a VDP secretary. My lord. My lord. Yes, yes, my lord, I have submitted before you by a fit, my lord. I have mentioned, my lord, can you see, my lord, a page, my lord, 45 onward. Page 45 is PW4. 4, 5, and 6. 6, 7. 4 is my lord in the affidavit. Yes. 4 is Arjun Limbo, my lord, and 5 is Amar Doimari. Amar Doimari is saying that I do not know anything about the case. 5. Amar Doimari. And 7 is, my lord, is a Kusum Kolita. Looking into the length of their, my lord, jail hajat, my lord, 9 months, 3 days. My lord, 279 days.
Two petitioners.
Two petition, my lords. আচ্ছা বলাই
Yes, Lordship. No regular bail application, my lord. It's a charge-sheeted matter, my lord. The TCR which was called for, my lord, has been received. Lord, 180 days behind.
My lord, here also P. Pathakar was there earlier, my lord. He is the another court, my lord. Next in the another court, my lord.
TCR has been received, my lord.
Can TCR, my lord, here is.
Obliged, my lord. Highly obliged. Obliged.
May I please, your lordship? In this case, my lord, the petitioner is aggrieved by order dated 11/1/2023, passed by the learned sessions as Jorhat, wherein, my lord, the learned court below was pleased to discharge the accused person under section 302 IPC at the time of charge hearing, my lord. Challenging that order, the present petitioner is the informant of the case. Referred this criminal petition before this honorable. For a moment, if your lordship peruse the FIR, it is in page number 14, Annex 1 of my petition, madam. The vernacular is in page number 17. May I read, madam? বিনীত সন্মান সহকাৰে আপোনাক জনাও যে কালি ইংৰাজী 5-3-2021 তাৰিখ শুক্ৰবাৰে মোৰ ভাতৃ শ্ৰী গোপাল কৃষ্ণ দাস উইদিন ব্ৰেকেট সিদ্ধি আমাৰ স্থানীয় দিগন্ত দাসৰ ঘৰত আছিল বুলি তেওঁৰ পুত্ৰ বিকি দাসৰ দ্বাৰা জানিব পাৰোঁ। বিকি দাসে নিশা 10:45 মান বজাত মোৰ ঘৰলৈ আহি জনাই যে মোৰ ভাতৃ শ্ৰী গোপাল কৃষ্ণ দাস সিদ্ধি সিহঁতৰ ঘৰত অচেতন হৈ পৰি আছে বুলি। লগে লগে মই তেওঁলোকৰ ঘৰলৈ যাওঁ আৰু দেখোঁ যে সেই সময়ত মোৰ ভাতৃৰ সিহঁতৰ সোফা এখনত পৰি আছে। তেওঁক বিকি দাসৰ সহযোগত মই ঘৰলৈ লৈ যাওঁ আৰু সুস্থ হোৱা দেখা নাপায় তৎক্ষণাত যোৰহাট মেডিকেললৈ লৈ যাওঁ। চিকিৎসকে চোৱা চিতা কৰি লগে লগে মৃত বুলি ঘোষণা কৰে। মোৰ সন্দেহ হৈছে যে বিকি দাস আৰু তেওঁৰ পৰিয়ালৰ লোকে মোৰ ভাতৃ শ্ৰী গোপাল কৃষ্ণ দাসক ষড়যন্ত্ৰ কৰি হত্যা কৰিছে। সেয়েহে ইয়াৰ এটা উচিত তদন্ত কৰি দোষী ব্যক্তিক সকলৰ ওপৰত আইনগত ব্যৱস্থা ল'বৰ বাবে প্ৰাৰ্থনা জনালোঁ। Was the FIR, it was registered under 302/34 IPC. And during investigation, police arrested the respondent number 2, the accused person. And thereafter submitted charge sheet, lordship. The charge sheet, lordship, will find in page number 18, annexure 2 of my petition. Charge sheet also, lordship, the same sections were revealed, 302/34 IPC. Thereafter, lordship, the trial court at the stage of charge hearing discharged the accused person from the charge of 302 IPC. Lordship will find the impugn order 11/1/2023 in page number 40 of my petition. Annexure 7, and that is impugn, lordship. May I read the order? Accused person, namely Sri Dipankar Das, is present in the court today. I have heard learned public prosecutor Jorhat as well as learned counsel for the defense. I have also considered the record of the case and the documents submitted therewith. The case was registered for filing of an FIR by one Sri Dharani Kumar Das on 6/3/2021 before officer in charge of Jorhat Police Station inter alia, stating that on 5/3/2021 at about 11:45 p.m. accused Vicky Das came to the house of the first informant and informed him that the brother of the first informant, namely Sri Gopal Krishna Das alias Siddhi, is lying in their house. Accordingly, when he went to the house of accused, he saw his younger brother lying on a sofa, and thereafter, with the help of the accused, the younger brother of the informant was brought to the house of the informant. However, as the condition of Gopal Krishna Das alias Siddhi deteriorated, he was taken to the hospital. However, there he was declared broad dead by the doctor. The first informant has stated in the FIR that he suspects that the accused Vicky Das and his family members have conspired and killed his brother Gopal Krishna Das. On receipt of the said FIR, the officer in charge
of Jorhat Police Station registered Jorhat PS case number so and so under section 302/30. Yes. I have stated in my ground, my lord. For a moment, if your lordship peruse my grounds of my petition, lordship will find in page number 8 of my petition. May I read it? Page number 8 of my petition, Your Honor. From ground number 2. May I read, Your Honor? Yes, I'll not read the whole petition. My submission before your lordship is that at the time of charge hearing, the documents available before the learned trial court was the copy of the FIR, the copy of the charge sheet, and the 161 statement of the witnesses, and the medical documents, forensic document, and other documents. But those documents, the medical documents, were not the substantial evidence, because without adducing the evidence, given opportunity to the informant and other witnesses, material witnesses, as well as the medical officers. Lordship? Lordship, for a moment, if your lordship peruse the forensic page number 31. Organophosphorus insecticides are there. The brother of the informant was found lying dead in the house of the accused person, and he was dead in a suspicious condition. Although there is no eyewitnesses are there, but without going through the materials of the case, I don't have the 161 statement also, my lord, because I have not called for the court to get the copy of I have nothing in my hand. I am the informant only. I have the copy of the FIR and charge sheet. The court perused the records from the records and found that there is nothing on record to prove the case of against the accused person. It is the person of the learned trial court. In this regard, may I rely upon a judgment of the Supreme Court, my lord? Yes. I am also not aware about the 161 statement, my lord, because I cannot obtain the certified copy from the record. I have the other document, my lord, I have already annexed with the petition, my lord. The postmortem and other forensic report.
My lord, in the house of the my lord accused. My lord, that may be applicable. My lord.
The prayer on behalf of the informant is that, Your Honor, he is taking for a fair trial because he is not getting any opportunity to adduce his evidence on behalf of his brother, dead brother. He is seeking justice. That part is not revealed either in the FIR or in the charge sheet, but after investigation, Lordship, the police collected the material and also submitted charge sheet. This is not a final report. Okay.
Statement of the my lord, informant তো ঘটনা সিহঁতৰ পৰিয়ালৰ ভাই গোপাল কৃষ্ণ দাস my lord, and other witnesses also in the other witness my lord, বহুত ল'ৰা হয় সেয়ে সাসপিশন মানে যদি
Lordship, actually, I'm relying upon a judgment of the Supreme Court, where actually the learned court below relied upon a judgment of Union of India versus Prafulla Kumar Samal, page number 42 of the relevant portion. That judgment is also considered in this particular case by the Supreme Court. It's a that is particular case, the petitioner agreed by a order of High Court of Honorable Jammu Kashmir, where the court below, the sessions judge, discharge the accused person under section 302 and frame the charge under section 304. The Supreme Court observed that, may I read the relevant portion? A copy. It will available. If your lordship peruse page number 673 onwards, para 30. Observation of the Supreme Court, my lord. May I read para 30? Honorable High Court set aside and let the trial court to frame charge under section 302. Another judgment, a small paragraph only, my lord. Para number 12, a small judgment. May I read it? I'll place before lordship later. Though the circumstances alleged in the charge sheet are to be established during the trial by adducing the evidence, the allegation of the charge sheet show a prima facie case against the accused, respond number 1 and 2. The circumstances alleged by the prosecution indicates that there are sufficient ground for for proceeding against the accused. At the time of framing of charge, only prima facie case is to be seen. Whether case is beyond reasonable doubt is not to be seen at this stage. At the stage of framing of charge, the court has to see if there is a sufficient ground to proceed against the accused. While evaluating the materials, strict standard of proof is not required. Only prima facie case against the accused person is seen. In this case, the court observed like that. My brother found dead in the house of the accused person. Yes. Yes. When the informant, my lord, my respectful submission is that, my lord, that when I was not present at the place of occurrence, I can only suspect. I cannot say that yes, he murdered or his father or mother was involved in that particular offense. When I was, admittedly, I was not present. I was in my residence. The person informed me. When I went there, I found that my brother was lying in the sofa set. I took him to the hospital. Doctor said they brought dead. But I can only suspect. That's why in the fairly he mentioned in his FIR. My respectful submission is that, my lord, only the last submission, my lord, that at this stage of charge hearing, considering the materials available before the court ought to have framed charge, and thereafter, after trial, if he released and discharged, acquitted, whatever documents I have already placed before your lordship.
Charge sheet only mentioned that alcohol, that is dear charge sheet, my lord. But otherwise, 3 witnesses are only dear, my lord. Charge sheet 7 witnesses are.
Obliged, lordship.